Ms. Kerpis, Ms. Salumi, Mr. Bernozzi, Mr. Milano. We have a full quorum, all 7 present and accounted for. Good evening, everyone. My name is Rick Finucci. I serve as solicitor to the Jessup Borough and Jessup Borough Council. Tonight's hearing is being held by the Jessup Borough Council regarding the substantive validity challenge and request for a landowner curative amendment to the Jessup zoning ordinance, which has been brought by Lackawanna Energy Center, LLC, by way of their application dated February 24, 2015, and a supplement thereto dated March 17, 2015. This hearing is brought pursuant to the Pennsylvania Municipalities Planning Code, Section 916.1 and 609.1, as well as all other relevant provisions of the code and the Jessup Borough zoning ordinance. A complete copy of the application submitted together with the supplement and all explanatory material and proposed ordinances will hereby be marked as Board Exhibit Number 1 and made a part of the record. Copies have already been provided to the court reporter. Can everybody hear okay, folks? Are we good? Thanks. The challenge in application substantially calls into question the validity of Jessup Borough Zoning Ordinance Section 3.324 and essentially argues that that particular section of the ordinance are de facto exclusionary in that electric power generating power plants serving a power system, including a cogeneration plant, are permitted as a conditional use in the M2 zone, and notwithstanding that no such use is possible based upon the ordinance's restrictions contained in 1, Section 5.232D, setting forth a 2,000-foot setback from other development, 2, Section 3.325, Schedule III-M and 4.210, in setting forth certain height regulations and in failing to exempt such a use as with other such similar uses, and number 3, Section 4.810, in requiring such uses to be completely enclosed in the C and M zones. As directed by Section 609.1 of the MPC, the challenge and application was submitted by the borough to the Lackawanna County Regional Planning Commission, as well as the Jessup Borough Planning Commission for their review and recommendations. Public hearings were held by each entity, and Borough Council received recommendations back from each, namely from the Lackawanna County Regional Planning Commission dated April 9, 2015, recommending that Council approve the validity request by essentially amending its ordinance to include this use as a conditional use in the M1A zone with certain conditions. From the Jessup Borough Planning Commission, we received a letter back dated today, April 27, 2015, from the chairman, simply stating that Jessup Borough Council, Planning Commission denied the request, and that recommendation that council denied the request. The letter from Lackawanna County Regional Planning Commission will be marked as Board Exhibit Number 2 and made a part of the record, and the letter from Jessup Borough Planning Commission will be marked as Board Exhibit Number 3 and made a part of our record. Notice of this hearing has been properly advertised in accordance with Section 610 and all other relevant sections of the NPC, as well as the Jessup Borough zoning ordinance as required by law. A legal ad has had run in the Scranton Times, a newspaper of general circulation, once a week for 2 consecutive weeks, no less than 7 days prior to today's hearing, and no more than 30 of. A true and correct copy of the newspaper ad will be marked as Board Exhibit Number 4 and will be made a part of the record. In addition, copies of the entire application, challenge, request, and proposed ordinances were duly delivered to the Scranton Times and Lackawanna County Law Library as mandated. In addition, notice of the hearing was duly posted in a conspicuous location no less than 1 week prior to tonight's hearing. The sole and narrow purpose of tonight's hearing is, and any possible continuation thereof, is solely to determine whether the substantive challenge to the ordinance as set forth by the applicant in their application has merit. Namely, that those sections of the ordinance cited are de facto exclusionary as to this particular use and for the reasons stated therein, and as a result, defective. The hearing tonight is being duly transcribed, as required by law, by a certified court stenographer, Mr. Mark Wanzi. And the record that will be produced will be considered the official transcript of these proceedings as required by law. This meeting is an official proceeding brought in accordance with the mandated provisions of the MPC and are unlike all prior meetings which have been conducted previously hereto by council or the planning commissions. And this hearing mandates that the necessity of an official transcript and that all testimony given tonight be provided under oath. The only parties to this hearing at this point are the applicant, Lackawanna Energy Center, LLC, and they are present and represented by their attorney, Craig Wilson. And the other party is a group of several residents of the borough of Jessup, who will be referred to as resident objectors, who I will name as follows. Pat Bryla, Gerald Cronella, Emily Davis Palermo, Kathleen M. Fiorelli. And Mark, if you need any spellings later, I can help you. Ricardo Horn, Ron Cordish, Peter J. Larioni, Corey Mahan, Alexandra Mosher, Gloria Miraz, Angela Mushaw, Gloria Munley, Patricia Munley, Serta, Joanne Pashodi Mosher, Janine A. Pavlone, Joyce Pavlone, Jason Petrachko, Holly Petrachko, Joseph Piccone, Richard Skoluich, Cynthia Sebastianelli, Helen Sebastianelli, Rella Scassavati, Ron Sebastianelli, Sam Sebastianelli, Lisa Simon, Rita Stella, Joe Tini, Bonnie Erzin, and Anthony Wrightson. And those individuals are collectively referred to as objectors and are represented tonight by their attorney, who is present, Attorney Don Miles. Please note for the record that Attorney Miles has duly provided counsel with his official entry of appearance on behalf of his clients and a listing of his clients' names for the record. Please be advised that any and all other persons, entities, or organizations who wish to become considered parties to these proceedings must enter their appearance as parties in writing and submit same for the record. I will be serving as the chairman of the proceedings tonight, as well as legal advisor to council/board. The formal rules of evidence shall not be stringently held in effect this evening. However, it should be noted that any irrelevant, immaterial, or duly repetitive evidence may be properly excluded pursuant to Section 908(6) of the MPC. Also, all rulings shall rest solely in my discretion, with any objections to same being properly noted for the record by the attorneys. The appearance fee for the court stenographer this evening shall be shared equally by the applicant and the borough. The cost of any original transcript shall be paid by the party requesting same or by any person appealing any decision of the board if such an appeal is made. In any event, any additional costs of any other copies must be paid by the person requesting same. If a determination is ultimately made by council that the application be denied, then the matter will essentially be concluded and no further action will be taken, barring, of course, any further appeal that may be taken to the court, which is the prerogative of either party. If council ultimately determines that the application has merit and that the ordinance is defective, then council will continue with the next phase of the proceedings to determine what the appropriate cure will be, whether it be to accept one of the proposals submitted by the applicant or to adopt an alternative amendment on its own. In doing so, council will consider various factors set forth in section 609.1C of the MPC and will also entertain public comment prior to making any decision or official action, or taking any official action. It should be noted for the record that Lackawanna Energy Center LLC had agreed to an extension of the 60-day time requirement from the date of the submission of the application, which is mandated in the MPC, and in which to hold this hearing until today's date. So we do have a written extension from them. Everyone who is in this auditorium tonight has been invited to be here and is welcome to be here. However, let's all please keep in mind that we must insist on complete civility, decorum, and proper conduct at all times during the course of these proceedings. Understand, folks, that it is extremely important to all of us, most particularly each of the parties to this matter, to have each of their respective cases and arguments heard without any distractions or interruptions. Similarly, it's imperative for counsel to be able to concentrate on the testimony that is to be presented in order to continue with its determination and deliberation. Almost last, but not least, we do have a court reporter present. As you can see, who will be taking down every word for the official record. It is extremely important that only one person speak at a time, and the official integrity of this, or the integrity of the official record, must be maintained in the event of any appeal to the court, as the official transcript would be the main device from which any court would have to go by in the event of a review. We cannot tolerate any shout-outs or remarks that are made outside of the proceedings by the parties. Anyone who's deemed to be disruptive or out of order, the proceedings will be suspended, and that person will be asked to leave and will be asked to be escorted out if they don't do so voluntarily. And we certainly hope it would never come to that, but we need to maintain the civility and integrity of the proceedings. The applicant, Lackawanna Energy Center LLC, after there will be a brief 3-minute opening statement made by each of the attorneys for each of the parties. And once that happens, the applicant, Lackawanna Energy Center, will proceed with its case in chief first and with the calling of its first witness. Attorney Miles will then have opportunity to cross-examine and question each and every one of the witnesses presented by the applicant. Once the applicant's case in chief is concluded, they will rest, and then it will be the objector's opportunity to present their case in chief and present their witnesses, with similar cross-examination being allowed by Attorney Wilson. In the event that there is not sufficient time this evening to conclude each of the parties' respective cases in chief, a new date and time for a continuation of tonight's proceedings will be announced, and we will recess these proceedings until that time. This will happen later on, depending on how far we get along in these proceedings this evening. I would ask at this time that all cell phone and other electronic devices are turned off or please silence, please. Lastly, and this is lastly, despite the fact that this is not a normal council session and is being held under the relevant provisions of the Pennsylvania Municipalities Planning Code, nonetheless, I would like to announce that as required by the PA Sunshine Law, that council did in fact hold 2 separate executive sessions between the time of their last official meeting and tonight's meeting, namely on April 15, 2015, and again on April 22nd, 2015, and that those 2 executive sessions were for the purposes of discussing a litigation matter as well as other identifiable matters for which litigation is anticipated. At this time, I will turn the proceedings over to the attorneys, starting with Attorney Wilson, to give his 3-minute opening statement. We have a man upstairs, Mr. Rupert. We thank you. By the way, excuse me, Attorney Wilson, on behalf of Jessup Borough Council and all of us. We want to thank the Valley View School Board. Try it.
Is that on now?
Yeah, just have to there.
Keep the mic.
You have to get real close. We want to thank the Valley View School Board and Mr. Canady, the superintendent, for giving us permission to be here. Without them, this proceeding really wouldn't be possible. It wouldn't make it as comfortable as it is for all of us to proceed. So we want to give them thanks, and to the maintenance men who were so gracious in setting things up for us, and our security, Mr. DeLeo, Ms. Evans, Mr. Serva, and our Jessup officers, who I didn't see who's here tonight, so I apologize. And last but not least, Mr. Rupin, his student assistant. Thank you. Attorney Miles?
Well,
Excuse me, Attorney Wilson. Excuse me.
thank you, Solicitor Invenergy. Good evening, council members, and to Mr. Miles and his clients. I'd like to introduce, before starting, the gentleman sitting with me, Dan Ewan of Invenergy, which is a parent company to Lackawanna Energy Center, and my partner, Chris Nestor, to his left. I'll be brief in this opening statement. As Solicitor Finucci stated, this is a substantive validity challenge and a request for a curative amendment. There are two parts to this proceeding. The first part, the validity challenge, is premised simply on the fact that the zoning ordinance of the borough unlawfully excludes electric power generation facilities of the type that my client proposes to construct. It does, on its face, purport to allow electric power generation facilities that connect to a power grid. But when the restrictions of the ordinance are applied, you can't actually build a plant. The M2 zone does allow electric power generation as a conditional use, but there are three restrictions that actually preclude the development of those types of projects. The first is a 2,000-foot setback or separation distance that applies to all conditional uses. It's 2,000 feet from any existing development. And when you extend that 2,000-foot separation distance within the M2 zone, there's no room, zero land available to develop a conditional use. So a power project could not possibly be built in that zone in compliance with that condition. There also is a height limitation, 40 feet in the ordinance. Could go up to 70 feet by special exception. This power facilities of this type, though, are taller than 70 feet. Necessary equipment exceeds 100 feet, and for that reason as well, the ordinance is exclusionary with respect to these types of uses. The third problem with the ordinance is that there is a provision requiring that all equipment associated, structures associated with conditional uses be within a building. And there are necessary components with an electric power generation facility that customarily are not enclosed in buildings. And so that's a third reason for the challenge to the ordinance. It's our belief, and we expect the evidence will show, that you can't build an electric power generation in the M2 zone, as the ordinance purports to allow. And of course, it's unlawful to completely exclude a use or a type of use throughout the municipality. And we submit that the ordinance is invalid because that's effectively what has occurred here. With respect to the second phase of the proceeding, the cure, once the defect is realized, we've offered up alternative solutions, any one of which would solve the problem that we've identified. The first of those, option number one, would be to designate the parcel on which Invenergy wishes to build the project as an M2 project. If that were to occur, then the 2,000-foot separation distance would no longer be an obstacle for development on that parcel. Option 2 would be to add a new M1B district applicable to that same parcel. And the proposal we presented